interest of everyone's afternoon. So, welcome everyone. Thanks again for joining. My name's Natalie, and I'm the event manager at Employment Hero. Today's webinar is part of our Race to Year End series, aimed to help Canadian businesses feel less stress about the year-end process, including everything from payroll to important legal updates you should know before 2026. I'm really excited to introduce today's speaker, Alex Triber. He is the founder and principal lawyer at Triber Law in Toronto, where he specializes in labor and employment law, advising both businesses and employees. Today, Alex is going to walk us through his top 5 legal risks for holidays that business owners should be aware of as we head into that season. After his presentation, we'll open the floor for your questions. So please use the Q&A function at the bottom bar of your screen to ask those questions, and we will get to them then. So without further ado, Alex, I will hand it over to you.
Awesome. Thanks, Natalie, for that introduction. And thank you, Employment Hero, for having me today. And thank you all for joining today's webinar. Every year, beginning around this time of year through the end of January, I get phone calls from businesses and individuals related to holiday parties gone wrong. And, I want to make clear from the outset that I have no interest in being the fun police. But as the holiday season approaches and many employers like yourselves are preparing to host celebrations meant to show appreciation, strengthen culture, and, frankly, end the year on a high note, there are unique sets of risks that employers cannot afford to overlook. And today, as Natalie mentioned, we're going to be talking about the top 5 holiday party risks to watch for and explore practical steps that you can take to protect your employees, your organization, and your organization's reputation. With the right preparation and awareness, you can host an event that's enjoyable, safe, and aligned with your company's values. So just a little bit about me before we get into today's topic. I've been in this labor and employment space for better part of the last 13 years or so. First as an HR professional at the Ontario Securities Commission, and then I used to practice exclusively for management and employers at a large Toronto Bay Street firm for a number of years. I had a brief 3.5-year stint at a law firm in New York City, representing large multinational corporations in a broad range of commercial litigation disputes. I'm also a sessional instructor at Windsor Law, teaching the next generation of labor and employment lawyers on a course on labor arbitration and new this winter employment law. Finally, I'm active in the labor and employment bar as an executive member of the Ontario Bar Association Labor and Employment section, where I regularly give talks on hot topics in employment law. I started my own firm in March 2024 to offer the same suite of Bay Street and Wall Street services to businesses and individuals without charging an arm and a leg. So let's get into today's topic and an agenda for our conversation today. So we're going to be talking about those top 5 holiday party risks, and I've categorized them into 5 risks. There's a lot of overlap, as you'll hear today, between the risks. But risk number 1, inclusion and accommodation. Risk number 2, health and safety. Risk number 3, harassment and discrimination, which is closely related, of course, to health and safety. Risk number 4, alcohol-related liability. And risk number 5, reputation and privacy. So let's talk about risk number 1. Broadly related to inclusion and accommodation. Inclusion at holiday parties is not about watering down celebrations. It's about ensuring that employees feel welcome, respected, and able to enjoy the event without compromising their beliefs, comfort, or identity. Thoughtful planning reduces legal risks and reinforces a positive, inclusive culture. The starting point for inclusion, in my view, is who are we inviting? And perhaps more importantly, who are we excluding? Sometimes employers make the mistake of not inviting employees to a holiday party that are on, for example, a medical leave of absence or perhaps a parental leave. By making a distinction based on a protected ground under human rights legislation, such as disability, or family status, you might end up with an application against your business at the Human Rights Tribunal of Ontario. In all likelihood, these folks, they may very well not attend or not be able to attend. But it is important that we extend the invite to all employees and ensure that we are not excluding employees simply because they may be away from the workplace due to a leave of absence. We also, on the flip side of this, we may not want to invite certain kinds of workers. For example, if you have a significant number of independent contractors in your workplace that may very well be misclassified, the more that we treat them like our employees, including having them at workplace employee holiday events, this could become a factor into the analysis of misclassification. The next thing to consider is picking the date. When are we going to host our holiday party? We need to make sure that when picking the date, we're not inadvertently scheduling events on dates that conflict with religious holidays. Many employees feel torn between respecting their beliefs and showing up for a company event. One of the things I will recommend to my clients is to take a look at a diversity calendar online. They're all over the internet, and you can look to see if your preferred date is conflicting with a religious holiday or event. What about the actual space? What about picking the venue? So when we're looking at the venue and we're looking at the space, we also need to make sure that if we have employees that have accessible needs, that we ensure that the venue is accessible. Does it have ramps, elevators, accessible restrooms? Is there accessible parking and drop-off areas that are close to the entrance that will allow employees with physical disabilities to readily be able to access the space for your selected holiday party venue? We also want to make sure that the theme of our holiday party is inclusive. Holiday parties often default to Christmas imagery, musics, or traditions, and this can unintentionally make employees of other faiths or no faith feel excluded or pressured to participate. It's important to reinforce that this event is a seasonal or year-end celebration, not tied to a specific religious holiday. Another important factor that can come up and that can often be overlooked is accommodations with respect to dietary restrictions. Food can be a major issue, and you'll want to ensure options, where applicable in your workplace, for halal or kosher food options. You also want to be mindful that there are employees who abstain from alcohol for religious, cultural, medical, or personal reasons that may feel excluded or singled out if employers put pressure on employees to participate in drinking games or focus the environment solely around drinking. Let's move on to the second risk, health and safety. So the Occupational Health and Safety Act, and I saw in the comments that some folks are outside of Ontario, and so these remarks are focused on Ontario, but it's important to note that across Canada, we have very, very similar legislation with respect to duties that employers have. And specifically, the Occupational Health and Safety Act in Ontario imposes duties on employers to take all reasonable precautions to protect workers, including at employer-sponsored events such as holiday parties. And holiday parties create a unique set of health and safety risks. And some of those risks include alcohol-related risks. Impaired judgment and coordination increase the likelihood of slips, falls, other injuries. Overconsumption can lead to workplace violence, workplace harassment, sexual harassment, medical emergencies, or unsafe behaviors. Related to this is driving under the influence, and we're going to talk about a couple case examples later today that can create significant employer liability if staff leave the event impaired and something bad happens thereafter as a result of them over-consuming at your workplace holiday party. Specifically to slips, trips, and falls at the workplace holiday venue, there can be decorations, dim lighting, crowded spaces, unfamiliar venues can increase the risk of physical accidents. Likewise, if we're hosting this in the dead of winter, winter conditions, snow, ice, wet floors around entrances can compound hazards. Another risk can be food and beverage safety. allergic reactions or cross-contamination risks arise when food isn't properly labeled or managed? Are we asking our employees whether they have any allergies? Do we know or do we know the extent of those allergies and how we're managing the menu that we're offering at the workplace holiday party? Foodborne illnesses can also result from buffet style service or improper temperature control. A lack of alcohol free options, as I mentioned, can pressure employees to drink. There's also sometimes these holiday parties relate to events at venues like skating rinks or ski hills or parks or sports facilities, and that can introduce higher physical risk. With proper planning, though, employers can significantly reduce risk while ensuring the event is safe and enjoyable for everyone. On the slide, we include a number of best practices before, during, and after the event. Before the event, it's a good idea to review and circulate workplace violence and harassment policies. If you end up terminating someone for cause for harassment or workplace violence, which I have been involved in many cases related to workplace holiday parties, in part, the analysis that a court is going to consider is whether the employee was warned that their misconduct could result in their termination. As many of you will know, the standard of cause in this province across this country is incredibly high. And in the absence of a policy that warns, a policy that we have proof that the employee was aware of, you're going to have difficulty terminating for cause. And that can often be a very difficult pill for employers to swallow, that they have to pay severance to someone that may have harassed or engaged in workplace violence at a holiday function. You're also going to want to make sure that you train your supervisors to remind them that they may need to intervene if an issue arises. Again, in a termination for cause analysis, a court might consider whether the employer or your supervisor, who by extension represents the employer, condoned an employee's behavior. Did a supervisor laugh at an inappropriate joke that was made at a workplace holiday party? Did a supervisor promptly address the issue as it arose? During the event, and again, we're going to talk about this a little later today about some really terrible alcohol related liability cases. You need to ensure that if you're offering alcohol at your holiday party, that you monitor alcohol service. Hiring licensed or smart serve in Ontario is something that we have bartenders is critical over allowing employees to self-serve. You should also have an assigned manager or HR representative to oversee conduct. If an incident arises where an employee has drank too much, they need to be recorded and addressed immediately. After the event, make sure that all attendees are getting home safely and confirm that taxis and rides are arranged. I understand that there is a cost associated with employees taking taxis or Uber rides for that matter, but you need to remember, and again, we're going to talk about a little bit later with some case examples, that if an employee becomes intoxicated at your holiday party, drives home and kills someone or seriously harms themselves, your company could be sued and become liable. Another really important post-event activities is to ensure that you're following up with anyone involved in a safety or harassment incident. I have seen employers wait a month or 2 months after a workplace holiday party to conduct an investigation into conduct that they were aware of at the time of the holiday party. Again, if you're going to want to terminate an employee for cause, you have to act promptly and you cannot delay in implementing punishment, or again, a court's going to suggest that you've condoned the behavior. Finally, a thoughtful post-event review helps employers identify what worked well, what posed risks, and how future holiday parties can be made safer, more inclusive, and more engaging. A structured evaluation also supports due diligence and continuous improvement. So some recommendations, you might collect feedback from your employees, perhaps an anonymous survey on venue, activities, accessibility, food and beverage options, and overall comfort. You might review safety and risk management outcomes. Were there any alcohol-related incidents, injuries, or transportation issues? Did the venue layout contribute to or help prevent risks? You're going to want to evaluate inclusion and accessibility. Did employees with mobility, dietary, or sensory needs feel supported? Was the party inclusive of different cultures, religions, and comfort levels? Were non-alcoholic options and alternative activities offered? Did employees report pressure to participate? You also want to consider, conduct, culture, and legal compliance. You need to review any behavior-related issues, complaints, or policy concerns. Consider whether training for the next holiday party, harassment prevention, alcohol guidelines should be strengthened the following year. Identify as part of this post-event review opportunities for improvement, more structured programming versus free-form socializing, stronger alcohol management strategies, better communications about expectations and available accommodations, perhaps enhanced transportation options. Let's move on to the third risk and harassment and discrimination. Now, look, this is third risk is very much related to the second risk, health and safety. A common misconception for employers is that because a party is off-site or outside regular work hours, they're not responsible for the misconduct of their employees. And the case law is quite clear that workplace holiday parties can and will be considered an extension of the workplace where the event is employer sponsored. Under the Occupational Health and Safety Act, employers, as I mentioned, have duties to protect workers and take all reasonable precautions to protect workers. And that includes protecting them from workplace harassment and workplace sexual harassment. Likewise, under the Human Rights Code, employees are entitled to be free from discrimination in the workplace. And where harassment, sexual harassment, or discrimination is alleged at a holiday party, employers have a duty to investigate these complaints. A failure to initiate an investigation or even a timely investigation may hinder your ability to terminate the accused for cause and could expose your organization to fines under the Occupational Health and Safety Act and or potentially a lawsuit from an employee claiming that they have been constructively dismissed as a result of a toxic work environment. Events where alcohol is served can, of course, result in lower inhibitions and impaired judgment, which can increase the likelihood of inappropriate comments, unwelcome touching, or unwanted advances. Casual socializing can also lead to offhand remarks based on race, gender, religion, sexual orientation, disability, or age that could also constitute discrimination and or harassment. Likewise, and as we've discussed, events with Christmas-centric themes may marginalize employees of other faiths and party activities that contradict someone's beliefs like pressure to consume alcohol or having religious symbols in the workplace that may be found to be discriminatory. And it's important to know that as an employer, you may be found liable for your employees' actions. And in the case of KL and the numbered Quebec entity on your slide, the plaintiff in that case was a 90-year-old employee at a park, and her supervisor made repeated unwanted sexual advances at an end-of-season party held on the park's premises, and the employer allowed employees to bring their own alcohol. The supervisor in that case allegedly sexually assaulted the employee in a pool and later in her vehicle. And the court in that case allowed the negligence case against the employer to proceed on a theory that the employer could be vicariously liable for the supervisor's actions. And the court noted that an employer's duty to protect employees at employer-sponsored social events, especially where alcohol and isolated environments are involved. And the court considered that the event was employer sponsored and on the employer's premises, and alcohol consumption was permitted without meaningful control. This decision is a cautionary warning to employers that workplace social events, particularly those involving alcohol and limited supervision, can create conditions that expose employers to vicarious liability and negligence claims. Let's go to our next risk number 4, alcohol related liability. Building off the KL case, it's important to know and understand that employers have a duty of care to their employees at workplace holiday parties, and there are a myriad of significant risks that an employer can face if a holiday party goes wrong. The duty of care can include things like monitoring alcohol consumption, taking keys away from intoxicated employees, offering Uber and or a ride home. And it can also include things like providing food and non-alcoholic beverages and ensuring that alcohol service is curtailed. Under Ontario's Liquor License and Control Act, criminal liability for overserving can occur. There can be fines up to $100,000 for individuals, $250,000 for corporations, license suspension or revocation, and even imprisonment. You may have also heard in the news yesterday in Ontario that the Ontario government is actually considering imposing child support payments for drunk drivers that ultimately end up killing a parent of a child or a legal guardian of a child. So alcohol related risks are ever expanding, and currently, even in terms of our legislatures considering how to expand those kinds of penalties. And like the KL case, there are a number of cases out there that have explored the significant risks that employers can face following holiday parties. The first case on your slide there is Hunt and Sutton Group Incentive Realty from 2001. In that case, Ms. Hunt was an employee of Sutton Group. And in December 1994, Ms. Hunt attended an office party held at her employer's place of business during working hours. While attending the party, Ms. Hunt would regularly answer the telephone and she was expected to clean up after the guests had gone home. During the party, Ms. Hunt also consumed a significant amount of alcohol from the open, unsupervised bar supplied by her employer. The trial judge found that when she left the party later that evening, her blood alcohol level was more than twice the legal limit. After leaving the party, Ms. Hunt, along with five other individuals from the party, went to a local pub. And during their 1.5 hour stay at the pub, the trial judge also concluded that Ms. Hunt consumed an additional two drinks. On her way home from the pub, Miss Hunt decided to drive her own car home, and she slid into the path of oncoming traffic, and she suffered severe injuries. And she sued both her employer and the pub for negligence. And in his reasons, the trial judge was clear that Miss Hunt's claim against the employer was strictly based on the duty of care an employer owes an employee. The employer conceded that it did have a duty to keep the place of employment safe. However, it took the position that that duty did not include the requirement that employers were required to supervise the drinking habits of their employees. The trial judge disagreed and stated, I quote, I find that the defendant Sutton, as the plaintiff's employer, did therefore owe a duty to the plaintiff as its employee to safeguard her from harm. This duty to safeguard her from harm extended beyond the simple duty while she was on the premises. It extended to a duty to make sure that she would not enter into such a state of intoxication while on premises and on duty so as to interfere with her ability to safely drive home afterwards. The trial judge concluded the fact that Miss Hunt left her place of employment and went to a pub where she continued drinking, did not discharge her employer from its duty to ensure she returned home safely. The fact that Miss Hunt and her group stopped at a pub after leaving the party did not absolve the employer from liability. And according to the court, the employer should have reasonably foreseen or anticipated this result. In confirming that employers have a duty to safeguard their employees from harm, the court concluded as follows. I find that her employer insisted on her leaving, had her employer insisted on her leaving the keys at the office or on taking a cab home at the employer's expense, if indeed it was prepared to do so, would have resulted in the plaintiff having no other alternative but to accept. Furthermore, the court went on to say the employer should have phoned the employee's husband to come pick her up, or could have called the police, for example. There were some avenues the court said that the employer just simply failed to pursue, and especially considering at the time very bad weather conditions at the time in question. The result of this case is that the court ordered the employer to pay Ms. Hunt $300,000 in damages. Now, originally her damages were awarded at $1.25 million, but because she was found to be contributory negligent, it was reduced. The pub was also sued in this case, but the pub actually went bankrupt, and the employer ended up holding the entire bag of the damages in this case. Okay. This is a really clear example of what can really go wrong when employees are overserved. They drive home and get into a serious accident where they either injure themselves or injure somebody else. The exposure can be enormous. The second case on the slide, at the bottom of the slide, Jacobson and Nike Canada, is another cautionary tale. In that case, the plaintiff and several of his colleagues, all employees of Nike, went from Port Moody to Vancouver to set up a display for the employer and the employer Nike. And towards the end of their 16-hour workday, the supervisors brought in food and beers for the employee. The plaintiff, in that case, drank at least 8 beers at work at the location, and then went to a bar where he drank some more beer. And while driving home, he fell asleep and was met with an accident, which rendered him a quadriplegic. And even though the plaintiff had consumed all of the alcohol voluntarily and had consumed beers outside of the work site, the court held that Nike was 75% responsible for the plaintiff's injuries. And the court made the decision based on the fact that Nike had a common law duty to take reasonable care for the safety of its employees to get home safely after finishing work at a location that was not their regular workplace, and especially because it had supplied the initial 8 beers that the employee had consumed. Okay. I want to turn over to our final risk before I turn it over to you for any questions that you might have. So, turning to the final risk, reputation and privacy. Workplace holiday parties, while intended for celebration, can expose employers to significant reputation and privacy risks, including employee misconduct, harassment claims, social media exposure, and the unauthorized sharing of personal information. And some of these reputation risks include employee misconduct. So, alcohol consumption, inappropriate behavior, or offensive remarks can reflect poorly on the company if incidents become public. Now, it doesn't just have to be, and we'll talk about this a little bit later about social media exposure. It can simply be the fact that you get sued by an employee where in our open court system or the principle of open courts, the details of the case become available for public consumption. This can severely harm the company's reputation. Workplace parties can create environments where harassment or discriminatory behavior occurs, as we talked about, and that potentially can lead to legal action and reputational damage. Social media now exposure is a huge thing. Photos or posts by employees on social media. We all have phones now where we can almost immediately upload videos or pictures of things that are happening before our very eyes. And that can inadvertently associate the company with unprofessional or controversial behavior. Separate and aside from a workplace harassment and violence policy that you might have in your workplace, another thing to be mindful of is a social media policy in your workplace to ensure that your employees are not posting online or associating the company with unprofessional or controversial behavior. Internally, one of the issues that you can deal with is negative experiences or rumors from the event that can create a toxic work environment that can damage the company's image among employees. It can also damage your image among clients, partners, or the public. Other privacy risks can include, unauthorized photography or video. Employees may capture and share images of colleagues, perhaps colleagues that have become overly intoxicated, without their consent, potentially violating their privacy concerns or creating uncomfortable situations as between employees. Likewise, the disclosure of personal information can occur. Conversations or activities at parties may inadvertently reveal personal or sensitive information about employees. Like the other risks that we've talked about, some key mitigation strategies include establishing and communicating clear policy expectations, whether that's a code of conduct, whether that's a workplace violence and harassment policy, whether that's a social media policy. You name whatever policy it is, you need to make sure you've got one in the workplace and employees are familiar with those policies and that the consequences of breach is that ultimately they can be disciplined, including up to and including termination. You should, of course, provide guidance on alcohol consumption and professional behavior, including ensuring employees are aware that it is not appropriate to become overly intoxicated at a workplace event. And likewise, related to social media and photo exposure, encourage respectful photography and best practices with respect to social media. So those are the top five risks that I wanted to talk about today. Um, I think what we'll do now, Natalie, is turn it over for some questions. I think there's been a number in the question and answer box that I haven't yet looked at that we can deal with.
Yeah, there's some in the chat and there's some in the box.
Okay, give me 1 second.
Yeah, I'm happy to pose them to you on behalf of the people who asked, if that works for you.
Sure.
Okay, I'm going to start with Bo's question in the chat. They asked, do you have advice on handling an employee who's drunk? What instructions should managers get? Do you have any examples?
Yeah. So I think there's a couple of situations that will need to be addressed. Number one, I mean, if you are if you don't have bartenders, or if you don't have some sort of bar service, and it's self service, which I would not recommend, but if it is that, you need to cut the employee off. With respect to overconsumption. If you do have bartender or bar service, you need to advise them that that person needs to be cut off. Likewise, you may have to send the employee home or arrange and make sure, of course, that they haven't driven to work or driven to the party and ensure that they have a safe way of getting home.
Perfect. Julie asked a few questions. We'll start with the first one. She is a small company with a small team. Their holiday lunch party is on site at their office every year. For those who do consume alcohol, they will pay for their Uber ride home. What if someone doesn't take the Uber home and they choose to drink and drive? Are they liable? I'll start there, and then she had a follow-up question too.
Yeah, so I think it's going to be fact specific. I think the purpose of satisfying your duty of care is such that if the employee does things you have offered, for example, a Uber ride home, you have cut them off of alcohol, you have properly mitigated your risk, and nevertheless, the employee still deviates from your instructions, or you've, for example, policied and papered over that, you know, that they need to take a ride home and they can't drive home on their own accord and chooses to drink and drive. That's going to mitigate the amount of risk that you face. Now, I can't prevent you from being sued, of course, but in implementing all of these actions and giving them the opportunity or helping them get home in a safe manner, if they nevertheless, uh, carry on and drink and drive, the amount of negligence that a court may find is going to be less than had you not implemented those strategies.
Perfect. And her follow-up question was around serving alcohol. Is it required to have someone Smart Serve certified to serve the alcohol? For example, Julie is Smart Serve certified, but is it required at their office function?
Yeah, so we're straying a little bit from my employment law expertise. What I would suggest, though, is that you definitely, if you are serving alcohol yourselves, it should be the most prudent thing would be to host or to have the server be someone that is Smart Serve certified. I think sort of an open access of here's a bucket of beers or here's a bucket of of wine bottles is not going to be the most prudent approach. There should be some regulation as to ensure that it's not unfettered access, because you also then won't be able to monitor how much people are actually drinking in the absence of having someone serve. If you are hiring a third party vendor, you should certainly make sure they're Smart Serve. Certified, and likewise for yourself, if you are going to be, if someone within your office isn't necessarily a bartender, that server should likely be Smart Serve certified.
Great. I'm going to pop over to the Q&A box for a question from Laura. What about an event that is not hosted by our company, but by a vendor? Senior leadership is inviting employees to the event where an open bar is expected. Is this considered an employer-sponsored event? Or I guess, would the employer still be liable?
Yeah, I think if you, the employer, your management team are inviting employees to an event and it happens to be open bar, and the same risks that we've talked about today about you hosting your own parties apply here as well. You ultimately are creating a nexus between the workplace and whatever this event is because you are inviting your workforce to attend that event. So, is it going to be in terms of when we're looking at a continuum of risk, is it going to be the most risky in that it's not an event you've hosted? That's right. It's not going to be on the same level if you are the host and it is entirely sponsored by you, but you ultimately are the ones that are creating, the invite or the avenue for your staff to attend that event.
Perfect. Samantha asked, what are some best steps to take in regards to the alcohol-related liability? Once the party's over, you can't force everyone to go home if they're going out to a pub or bar afterwards. How does the
Yeah.
company protect themselves from that liability besides, offering to pay for their ride home, for example?
Yeah, so I think this is sort of a very similar question to the Hunt case, right? Which was sort of the list of things that the court said the employer did wrong, which was they never offered them a ride home with vis-a-vis a taxi. They never offered to call, that person's spouse or, significant other or emergency contact to collect them from the workplace. They did nothing to disrupt the sort of next event that where folks go out after the event, after the employer sponsored holiday party. So the key piece, I think, for mitigating your risk from the employer's perspective is documenting all of these things, which is we offered you an Uber ride or a taxi ride home. We took away your keys or threatened to take away your keys. We told you specifically that you were over consuming. And again, we're making sure that we have a record of all of these things. You will have managed that risk. Now, it's not going to go away completely, right? Because you are the sort of original event that eventually led to the person going to the pub, just like in the Hunt case, where there was a workplace holiday party and then they went to a pub, they drank more, and then they got into an accident, and the employer was ultimately found to be contributory negligent. In a case in which you are satisfying your duties, which is you're making those offers, you can reduce your exposure to risk, but it will not ultimately entirely go away.
There was a question about a social media policy. Is there a template or would you be able to help them draft one? I would assume perhaps they could scan this QR code and reach out to you directly to chat about that.
Yeah, that's right. So up on your screen is a QR code, Q card, excuse me,
Mhm.
QR code, which will directly link to my email. And if you want to reach out to talk about, how my firm can assist, whether it's drafting a social media policy, whether it's drafting a workplace violence harassment policy, or even a holiday party policy with respect to alcohol consumption or otherwise, happy to do so. Please reach out and we can connect from there.
Perfect. Tanya was asking a question about the health and safety risk in terms of pre-event considerations. It was recommended to train supervisors on how to intervene if any issues were to arise. Do you have any examples on what specifically they should be trained on when it comes to that?
Yeah, so I think there's a number of facets of this. So training specifically on your workplace violence and harassment policy is actually a requirement under the Occupational Health and Safety Act, and typically it should be done annually. And one of the things you might explain to your supervisors, and particularly when you're in sort of a more casual or informal setting, the way that employees speak to each other may sort of go down a path where it's somewhat inappropriate. Supervisors need to be mindful of and reminded of the employer's obligations under the Occupational Health and Safety Act, which is to protect workers from violence and harassment. And so, if a supervisor is involved in a conversation, for example, where employees are speaking inappropriately to each other, they've got to intervene. They've got to document, just as they would in the normal course. If you were at the workplace in sort of your standard 9 to 5, and a supervisor came across, inappropriate comments or jokes or otherwise. Likewise, if a supervisor sees that an employee is intoxicated or has overconsumed, that needs to be flagged, whether it's to HR, to a designated manager, designated supervisor, or otherwise. There needs to be sort of an appropriate or system in place such that we spot the risk and we deal with it as is. It's not likely okay to just say, oh, it's just Joe and he'll be fine. I've seen him handle his alcohol before. You've got to address the issue head on as it comes up. So I think it's really about refamiliarizing your supervisors with policies that already exist in your workplace, but making sure that there's a timely addressing of these issues. Another issue that can come up, and I mentioned it in today's talk, which is, you know, a lot of times these issues come up a couple weeks later or a few weeks after the fact. It comes to the employer's attention a few weeks after the fact. And it also comes out in the course of, the investigation that a supervisor may have been aware that there was an interaction or inappropriate interaction between an employee or otherwise, and they didn't raise it with the employer. When we learn of incidents that could trip over our obligations under the Occupational Health and Safety Act, we have statutory duties to inquire and to look into and to investigate these things. And so another thing that you need to be mindful in training your supervisors is timely addressing of these issues as they happen. It's too late if we're waiting 3 weeks, 4 weeks, months to raise these things. And it can entirely hinder you from being able to, if determined that these complaints are true, to potentially terminate someone for cause. It is the worst conversation that I have ever had with employers when I have to tell an employer that because they waited too long to address an issue in the workplace, that they may have to pay that person significant severance, right? Like that's not a great conversation to have. So you got to be on top of these issues, got to be on top of managing and these behaviors in a timely fashion, as is statutorily required.
Yeah. Um, I wasn't planning on giving my input, but as an event manager, I will say that something that I've implemented just in my career is, having that post-event connect the next day, so that if anything were to arise, if there were any issues, people may not feel, comfortable to come to the team to talk about it immediately. But if there's, a debrief that perhaps a manager heard about something or there's something going on, it helps to kind of give everyone the platform to talk about it on the planning side. So just thought I'd mention that.
Yeah, yeah.
Mhm. If alcohol is served during a holiday party, can the employer allow employees to bring children? Is there any like rules around that?
Yeah, that's straying a bit from my expertise. I'd say generally speaking, as certain venues are only 19 plus, you should potentially operate your business that way as well, and be as prudent as possible. But I'm gonna uh, stay away from that one.
Yeah, sounds good. Emily asked, can a record of proof of attempts to mitigate drunk driving risks be as simple as keeping a list of events, or does it have to be signed off by the employee?
Yeah, so I think I'm always going to say as a lawyer, I want a sign off from the employee. I also understand that that is often not practically possible. But I do think if you have a written record, which is an email communication to staff or all employee communication outlining your expectations at an event or outlining your offers of taking an Uber home or we'll pay for your taxi and if you do choose to drive, that you have to, give your keys up, et cetera, et cetera. Having all of that in writing as communicated to employees is going to help mitigate your risks. On the workplace violence and harassment component of this, I mean, I think as part of a best practice, as how you operate your business, you should have employees acknowledge and sign off on those policies. And those are typically broad enough to capture conduct at a holiday party. You don't have to draft a policy specifically for holiday parties for you to know that you shouldn't sexually harass someone at a workplace function. So, where we can and where we, have policies in place, already, we should certainly on a regular basis have employees acknowledge that they're aware of, they understand, and especially that they understand that a violation of those policies could lead to their termination, including a termination for cause. That's going to really help in terms of mitigating risk.
Right. Have my event brain on just slightly for one more thing. Often
Sure.
we use like lunches or, team connects or whatever. And it's, fill out this Google form or RSVP here, is the re policy refresh about that conduct something that they could acknowledge within like a registration form or something like that? Would that be a good way
Yeah.
to acknowledge for that specific event and could even go down the path of we are offering these Uber rides. Can they opt in or out at that point? Would that be a way they could do it too?
Yeah, absolutely. That's a great idea. I mean, often when you're asking, the way you could even you know, posture this is when you're asking folks for like dietary restrictions, they also have to fill out a form that has basically everything that we want them to acknowledge and sign off of. And that, these kinds of forms can be really easily made online. And then you have, sort of written proof of the fact that, employees, acknowledge that they were aware of, the workplace violence and harassment policies, acknowledge that they're aware of social media and off-duty conduct policy, acknowledge that they're aware that the employer is offering, Uber rides and taxi rides, and by not, choosing to take that home, they are assuming, assuming the risk of having done so. Um, so I do think that would be a really good way to, document and sort of have, the ability to rely upon a document like that in case there is any litigation.
Yeah, for sure. There is a question. Can we conclude after this session that HR needs to have emergency contacts for all employees attending the work party at hand? Is this kind of in your realm or?
Yeah, I mean, listen, I think it's a best practice. I don't think it's, it's a legislative requirement. But certainly, if you don't have that kind of information, you may like this isn't necessarily applicable to a workplace holiday party. You could have an employee that has a medical episode at work. What
Yeah.
are you going to do next if you don't have that person's emergency contact information? It's not a legislative requirement, totally a best practice, but in that situation, it would be good to have that information, including for a workplace holiday party.
Yeah, I think it's also a good option, refresh your emergency contact is the one we have on file
Yeah,
even date. I think that's a good best practice as well. Um,
absolutely.
is what could be considered a reasonable amount of time before situations become expired or too long ago to address?
Yeah, so there's no sort of um, hard and fast rule with respect to the amount of time. What I can say in my experience in my practice, what I have found problematic is when a holiday party happened in December and then I get a phone call in February. We're starting to get a little stale here. Now, listen, sometimes we don't learn about these things until February, that no one was on notice. And particularly in cases of sexual harassment, it is well known that, victims of sexual harassment don't necessarily come forward for some time. That's still reasonable if that's the reason why. The issue or concerns I have is where when we have a supervisor or someone with managerial authority basically imputing knowledge to the corporation, right? So your supervisors have duties under the Occupational Health and Safety Act. Your HR team has duties under the Occupational Health and Safety Act, and often as supervisors. And so if they learn of these events as they're happening and then nothing is addressed until, February or otherwise, you're going to have some challenges there in terms of suggesting that you were timely in addressing, that complaint.
Awesome. And then there looks to be one more question. Hopefully, I've gotten to all of them. How sensitive do we need to be regarding Christmas party events versus holiday celebrations in terms of inclusivity?
Yeah, look, I think you do need to be sensitive about it. I mean, the reality is well, the holiday party originated as a Christmas party. We've kind of evolved from that, and the reality is that many Canadians, many Ontarians are not Christian and don't celebrate Christmas, and so I think you just have to be mindful. Listen, this is all about weighing your risk tolerance. You want to call it a Christmas party. You shouldn't be surprised if ultimately someone files, a human rights application against you. That could happen. Like that, I can't tell you that won't happen. And so you just have to be, mindful of your risk tolerance. I'm not going to sit here as a lawyer and say, call it a Christmas party and do whatever you like. That's just not the answer you're going to get from me. And so you just have to be mindful of, what your, company's risk tolerance level is. And particularly, if you get a complaint from an employee that says, I feel like I'm being excluded because I'm not Christian and this isn't, I don't know what Christmas is and I, don't want to attend a Christmas party. If in response to that you double down and carry on with a Christmas party, you might have even further problems. So I do think you ultimately need to be sensitive about it.
Yeah, absolutely. I think that's all the questions I've seen come through. I just want to say thank you, everyone, for
For
spending
sure.
the better part of the last hour with us. And thank you to Alex for popping on with your expertise. We do have another webinar upcoming on December 4th, all about benefits, trends, and best practices for 2026, if you're interested in joining that. And then the QR code to connect with Alex if you want those social media policies or etc. Updated or refreshed, it'd be a good opportunity for you to connect with him. Thanks for your engagement in the chat. I loved it. And best of luck for the rest of your year end. And we'll all connect soon. Thank you so much.
Thanks, everyone.